Tēnā koutou katoa, nau mai, haere mai. Greetings everyone and welcome to our latest NZ Free Law podcast, brought to you by ture.co.nz. And just to remind you, the purpose of the podcast is to assist with fulfilling Ture's mission, which is to connect New Zealanders with better access to and knowledge of legal services. So NZ Free Law talks all things law in New Zealand. Now, my co-host today is not Josh Brown. He's just had a new baby, so congratulations to him and his family. And so my co-host today is Morgan Samuel.
Thanks, Julia.
Good to have you here as a non-legal person asking some questions.
Absolutely, I can do that.
Yeah, great. My name is Julia Stenson, and my past experiences as a commercial lawyer in the Waikato, who is the founder of ture.co.nz and NZ Free Law. So now to our special guest of the day, who we've had the pleasure of speaking to in a previous episode on trusts, Sue Tappenden.
Hello.
Good morning, Sue. You're based in the beautiful Bay of Plenty. We were just talking about how close to the beach you are. Very lucky.
I'm jealous.
So Sue's talking to us again by Skype from the beautiful Bay of Plenty, and we're going to talk today about wills, and we touched on that last time and decided that it necessitated its own episode, as you may recall. To the legal word of the day, which is executor. So an executor is basically appointed by the deceased person through their will, and when the person dies, the executor is the person responsible for managing the deceased estate and their property and their home or whatever, and distributing the assets according to what the deceased person has put in their will as their wishes. So, Sue, could you say that that's kind of akin to a trustee role?
Yes, in fact, some wills will actually establish a trust, and the executor is often named as the trustee as well. The executor has responsibility, first of all, for paying bills that have been left by the deceased person and for getting all money in that's owed to them. And once they've done that, in fact, especially paying any tax that's due, because the taxman always gets his cut first, then they can start looking at the will and deciding who gets what. And if there's a deficit in the will, so say the person who's deceased, the testator, has said, okay, I want $30,000 to go to my daughter, but there aren't $30,000 in the estate, then it's the executor who has to decide, well, who gets first dibs of the money. So it's quite a responsible job, and you can refuse to do it.
And you can also have co-executors to share the role, can't you?
You can, and again, it's very common. The only problem is finding people who are not going to argue. So if you find family members, sometimes, sometimes it goes smoothly, sometimes it doesn't. So the court is always there to help.
And if you're the lawyer in the family, you tend to be asked to be everybody's executor.
Yes.
You sound like you might have been there before, Julia.
Yeah.
So what's the key difference between a trustee and an executor, if they can be the same person?
Well, the executor's for a will and the trustee is for the trust that's been set up in the will. And the trustee will have that job for as long as the trust exists. So possibly until they die, because a trust can last for 80 years. Whereas the executor, his role ends as soon as the estate's wound up.
Gotcha.
Okay, great. Well, I think that takes us quite nicely into the nitty-gritty of the broader legal topic of wills. So, Sue, can you tell us why someone might want a will and what kind of benefits they are? I know that sounds like a strange question, but some people just don't get them. They don't think they're important enough to have one.
Well, it's all about control. I mean, who do you want to control what happens to your money and your assets after you're dead? Do you want the government, the court, looking at a whole load of strict rules? Or would you rather have some control even after death over who gets what? And mostly in families, there will be certain, I don't know, say romantic connotations with some property. So, for example, in our family, all the girl grandchildren want my jewelry. And so by leaving a will, I can dictate who gets what and make sure it's divided fairly.
Right, right. And so really it's about the person being reassured that on their death, their assets can be distributed according to their wishes, the way they want it to be.
Yes, of course, there's not a guarantee, but it's a good start. If you don't have a will, then the Administration Act comes into play. That hasn't been changed much since 1969 when it was passed, and it talks about certain property over the value of $155,000. Well, if you've got something over $155,000, then it's shared. Your spouse or your partner will get a certain amount, and then after that it's divided between your partner and your children, and if there aren't any children, between the partner and the mother and father of the deceased person. Most people don't want that.
So that's in the situation where there hasn't been any will drafted. There isn't anything else to look to. Well, that alone would push a lot of people, I'd imagine, to think about getting a will, particularly if you've got children. And as you say, they want specific things because there's a attachment to those items.
I imagine you've probably been in a situation where there hasn't been a will, Sue. What's it like? Does it get messy because of the unsurety, or there's no real things that have been stipulated from the deceased?
Yes, it's a huge source of argument, even when there is a will. I believe there are some 300 cases that go to the court every year, even where there is a will. So you can imagine there isn't one, it's even more messy. Families tend to split into factions over property, I'm afraid. I think of farming families as well. There's a huge asset in the farm, but the court, the Administration Act, doesn't really have mechanisms for sorting those families out.
And so are we getting into sort of the idea of what probate is when we're talking around what process it goes through? What is probate?
Well, probate is not as difficult as it seems. It's really just a court administration role, so that the court will administer the estate according to set rules. The High Court can issue an order to confirm the last valid will of the testator, and this then gives the executor the right to administer the estate, so to give all the assets back by grant of administration. So probate is really a formality. The argument goes on around probate, usually.
Does that mean that every time, every will has to go through that process as a formality?
If you've got a small estate that you're dealing with, and I think the present limit is $15,000, then the family can just get on with it themselves. But once you get over that magic amount, then you're going to have to start getting some help. The public trust office can help if you don't feel confident enough to go straight to court.
How would somebody go about with the public trust office? You just ring them up and tell them?
You make an appointment with them and they'll go through the documentation and they help you. It doesn't cost very much either.
And that's whether there is a will or not?
No. If there's no will, then you would normally have to go. Well, I suppose you could go to the public trust office again and they would help you to sort out getting an administrator appointed. I mean, if the estate is more than 15,000, then I think you've got to have some kind of administrator appointed.
And you hear about these stories of it being tied up in probate for quite a long time if there's no will and there's a lot of money at stake.
It's because people argue a lot about it. And also, with the advent of the Wills Act in 2007, the court has a lot more power now. They don't have to just strictly abide by the letter of the will. I mean, the old will legislation that was brought over from the UK was written in 1837. And it was written for, not for the hoi polloi, but for people who had lots of money. And so the rules were very, very, very strict. The signature had to be a certain place on the paper. There were rules about if the will was written on more than one sheet of paper, where the signature should be on each sheet. There were all kinds of rules about it. And the court hung up probate by going through and making sure that all the I's were dotted and the T's were crossed. Since the Wills Act 2007, the court has a different role because the court can now amend wills that are faulty. They can declare an invalid will valid under Section 14, and this can hold things up. And also, of course, there are people who want to challenge the will, and that holds things up an awful lot.
Oh, so the court can do that whether someone is from the family or that ilk is actually contesting it or not. Why would they do that?
Well, there is a list of people who can contest that are attached to the family. So stepchildren, children who are born outside of the primary relationship, they're usually called ex-nuptial children. So what can happen is that you will have a family who have say the father in the family dies, and the mother and the children of the family are quite happy to divide up the assets, no problem at all. Then all of a sudden, along comes another person with the news that they're a child of the man who's just died, and they want a share of the will.
You hear that in celebrity stories all the time.
Oh, it happens more often in New Zealand than you like to think, especially because people travel around a lot. You get people having relationships, say, in England or Australia, dying in New Zealand, and the current family haven't got a clue that that the man's fathered these children overseas. And suddenly they come out of the woodwork. Oh, hi, I'm Jill. I want a share of the will.
Yeah.
Right. And so we'll come back to that. But what would someone need to do to have a valid will then?
It needs to be in writing. That's the main thing, in writing. It needs to be signed, and it needs to be witnessed by two people who aren't beneficiaries of the will.
Right. Okay, so it's about having it written down and having it witnessed, essentially.
Yeah, but of course, we're talking modern day. What about an email? It's writing. It's not what we expect. Can it be witnessed? Can it be signed? Well, you've got electronic signatures. That's a hard one. But we have had one case that I know of where an email was accepted as the will.
Wow.
But there is a big but here. In that particular case, the court allowed it because if there'd been no will at all, the person named in the email would have got the money under the rules of administration. But they said, okay, we'll accept this as the will, but it's rare.
Yeah, very rare. Okay.
Very, very rare. We've had some odd things about wills not being on paper. There's a tract offender in a university library. I think it's Saskatchewan. And in the university library there's a tract offender where a farmer who'd rolled his tractor on top of himself, scratched out his will with a fingernail, and that was accepted as a will. So there are ways round the rules.
Whoa. Is this like recently?
You're talking about Canada, aren't you?
I am talking about Canada. Is that recent? No, but it's there. It's in the rule book. It's in the precedents.
Wow.
So I could sign my will in blood and, it would have
Yeah.
a bit of extra
Drama.
wairua behind it. They'd have to accept
Yeah,
it.
as long as it wasn't disappearing blood.
Well,
As long as you haven't got lemon juice in your veins.
Slightly creepy.
Yeah, very creepy. You see online now all these do-it-yourself will kits, and I'm very sceptical about how robust they are. I know I think the only benefit I can think of is that it's meant to be cheaper, right? Because there's no lawyer involved at that point. But is it cheaper in the long run is my question.
Well, you may have to go to court to remedy the will if the person filling out the will doesn't quite understand all the ramifications of where names should go. For example, I've done a little bit of research on this, and it seems that that's the big downfall with these sort of fill in the blanks type wills that are online, that people put the wrong thing in the wrong blank because they misunderstand, because the terms are still the same: executor, beneficiary. Some people don't know what they are, so they've ended up putting the beneficiary's name where the executor should be, and vice versa. So they are
Messy, very messy.
They are messy, and they can cause more trouble than they're worth. And in the end, you end up with the family again arguing, and then you have to go to court, you have to go to a lawyer. And it can be more expensive and distressing, because the family think, oh yeah, dad's got the will, dad signed the will, that's fine. And then come to the day, the court says, no, we're going to have to look at this more carefully. But they can make amendments to the will, provided that they are secure in the knowledge that they understand what the testator really, really wanted.
The whole idea of having a will would almost be defeated because you've got to go through that long remedy process.
Well, that's right. It's almost better if, instead of using one of those online documents, you simply write notes. Now, these two have been accepted as the will. If a testator, there's one case where a testator wrote a list of all their assets.
Sorry, what's a testator?
Oh, I'm sorry, that's the will maker.
Okay, cool, thank you.
That's the person making the will. See, that's where the fill in the blanks will would fall down, because they'd be talking about, you are the testator. You could make a list of all your assets, and then you could make a list of all the people that you want to get the assets and indicate who gets what. And as long as that could be ascertained as being your final wishes, you just haven't got round to going to the lawyer and putting it in will form. So long as the court can accept that, then under Section 14, the court can say, this is the will. So that's probably better than using an online form.
Mm.
So is there any benefit to those online forms, or are they just...
Which is my point, really.
Yeah.
Makes me wonder.
They can make you think about what you're leaving, but I wouldn't use one. I wouldn't recommend anyone.
So there's no actual formal legality behind it that is any different to someone sitting down and writing down their wishes?
Well, I think the risk is that there could be, as Sue has said, imperfections with the way it's drafted, because the wrong names go or in the wrong places. And also it leaves it open to be contested a lot easier, in the sense that if you are not aware of some of the rules or whatever and you put it in there, because certain things. So if, let's say if I leave something to my nephew, but then I say that I want him to do something with it, I can't stipulate what he does with it. I can only stipulate that he gets it. Is that correct, Sue?
It's largely correct, yes. There isn't much in the way of precedent cases on that point, because it's something I was trying to find out for a friend of mine.
Right.
And that was the father was trying to control the daughter from beyond the grave. The best that I could come up with is by saying, if you try to attach a condition to the property, you're probably going to fail. And that piece of property would then go into big fund that's left afterwards. It would go into the residue, as it's called. Yeah. But if you were to say, if my daughter does so-and-so, then she can have the money, then that's more likely to be valid, because the money can then be held by the executor or a trustee until the daughter has complied with the wishes. For example, say a father is dead keen for a daughter to go to university. If he says she can have the money to use for university and that only, then that will fail. If he says as soon as she starts university, she gets the money, then that will succeed.
Right. Because it's sort of like an event rather than a condition.
Yes, that's right. So that's right. Absolutely right. What the courts don't like is these conditions precedent. So that's a condition that must be fulfilled by the beneficiary. They don't like that. So
wow, that's super specific, because really that's just wording, you know.
It is.
Those two sentences kind of mean the same thing, but one
Not if you're a lawyer.
could be pushed over. Yeah, exactly.
However, under Section 14, the High Court can now look at that and change it round to the one that does succeed.
To remedy it.
Yeah, so the will won't fail.
Right.
Or that part of the will won't fail. See, this Section 14 is absolutely fabulous because it gives the High Court huge powers. But of course, on the other hand, it's also very dangerous because the testator gets less and less control over what happens after death.
Well, I guess if you look at it from the perspective that the court will try and give their intentions as best they can under that section, though.
Yes.
To remedy it.
Yes, and they can take evidence from other people who the testator may have spoken to as to what their intentions were. So it's very much broader than it ever used to be.
How do you contest a will? You go to the court, basically make an application to the High Court, do you, as a claim?
You do. You would see the registrar and you would fill out the form to say that you wish to contest the will. So you'd have the details of the will and you would put down your grounds for contesting it. So it's not too difficult to kick off. What the difficult part comes is when you try and decide under which head you want to contest it, because there's loads.
Yeah. And so if I just go back to the Family Protection Act, for example, the courts generally the inquiry there is around whether the claimant has a maintenance, which is around the financial side, a need, and the second is the support, which focuses on the non-financial, so the emotional side.
Yes, that's a difficult one. It all comes under the heading of moral duty, and that's such a difficult one to decide. When the Family Protection Act came out in 1955, moral duty meant something completely different. It would have meant mostly financial. So if you had a son who you'd argued with and didn't want to leave anything in your will, then that son could then apply to the court and say, no, my father had a moral duty to include me. And then it would be fairly basic. It would be fairly basic maintenance. So nothing like the fair proportion of the will. So this idea of moral duty has been enlarged in recent times to include the element of support. Yes.
Right. And as you say, adequate provision for the proper maintenance and support is not the same as what might be an equal distribution that people want or think is fair.
Yes, that's right. And again, the court's got a very difficult job, because they have to look at the life of that person. Has that person maintained a decent standard of living? Did that person get money, say, from a deceased mother or other relative, which would lessen the need for them to have too much out of the present will? Was there a reason given for excluding this person from the will? That can also be very important. If the testator's explicit and says, no, this person has already had $500,000 for me to buy a house, I don't want them to have any more.
So does this process happen with every will?
No, not necessarily. We're talking about contesting.
Yeah, only if it's been contesting.
Yeah, and there's different grounds that you can contest.
Yeah.
And I think perhaps if we give a case example, it gets kind of more contextualised and it's a bit easier to understand. So, for example, one of the cases, more recent cases, Cartwright and Joseph, it was a multi-million-dollar estate of a father with two daughters who were estranged due to a marriage split that had happened years before. And it was no fault of their own, and they were actually financially stable, like from their own efforts, not their father. So the financial grounds for the court was not there, but the court did see that there was some emotional grounds where the father had actually failed to support them under this particular act, the Family Protection Act. And so they wanted 15% of the $4 million, and the court ended up giving them 10%. So, in that particular situation, it's worth the effort.
Yeah, but why would it have been a different amount to what they were asking for?
Well, it's simply a matter of the court looking at how much I suppose you could use the word deserve, how much they need. Do they need to have the full amount that they're asking for? Usually not. What's the proportion of what they're asking for in relation to how many other beneficiaries there are, and what they'll be getting? There's all kinds of factors that the court can consider and generally come to a lower figure.
And I mean, if you contrast that with another case, a Talbot case, where there was a farm actually included, and it's reminiscent of what you were saying earlier, so that there were 3 children, the son had worked on the farm for 20 years, the parents had said to all the children that the son was getting the farm because they wanted it to stay in the family. So everybody knew where they were at. And the 2 daughters ended up getting, I think, $1 million each. But they said, we want more, because obviously the farm was worth a lot more. But the court actually said, well, no, actually, you're financially sound. Your parents were emotionally good to you, supported you. So that's where it ends.
On grounds of what, had they not worked on the farm? Or was that what the difference was there?
No, I think it was more that the intentions were clear and they had actually received financial and emotional support. They'd been brought up well.
Yep.
They weren't in any real need, and they knew that was their parents' intentions for 20 years.
Okay.
And they'd had plenty of opportunity to make good careers for themselves and be financially independent. Yes, that's it. That's quite common. There was also one that I was looking at, which may be a few years old now. Carol Fry, I think it might have been 2017, something around there. Carol Fry went into a second marriage with her own home. So the house was actually hers when she went into the second relationship. And her second partner had a son. All 3 of them worked towards setting up a business. And Jason, that was the son, worked for the company, as did the new wife and the father. Now, there was 2 grounds that he could have contested the will on. The first was that he said the father promised him he would inherit half the company on his father's death in return for services to the company. But the second ground was this one under the Family Protection Act, which was that he had a moral duty. The father had a moral duty to leave him some money. So the terms of the will was quite strange, I suppose, to us, in that the children didn't get anything except a promise under a contract that on her death, the wife, Carol, would leave the property in equal divisions to the children. But in the end, the court said that, yes, there was a moral duty, and she had to give him $175,000 out of the estate. Now, in fact, the rider to that is that he probably would have got a lot more if he'd simply waited for Carol to die. But it cost her $400,000 to meet that contested will, to meet the claim.
What people forget is the cost of actually going through that process. Somebody's got to bear that cost, and it's usually the estate.
Yes, it's usually the estate. Yes, it's appalling, actually, because this tears families apart as well. Because this Carol Fry that I was talking about, she thought she had a very good relationship with her stepson, and then it turned out that no, they didn't. And so after that, instead of supporting each other after the father's death, they were split and they didn't speak again.
Yeah, that's really sad. Family Protection Act is an odd, perhaps it reflects that it was made in 1955, as you say, because what struck me is the order, the hierarchy of who the will maker has a moral duty to. Their spouse and their civil union partner first, their de facto partner next, their children, then their grandchildren, then their stepchildren, and then their parents. So, not everybody is going to have that hierarchy in the way they feel about their family.
Oh, no. And that's very similar with the Administration Act as well. Not everybody wants that hierarchy to be imposed. Absolutely right.
So I find that quite an interesting, if you look at that, that's one of the quirks, I think, of the law that you can use to contest if you're not in there and you haven't been adequately provided for under those 2 grounds.
The other thing, of course, about that particular act, as Morgan was saying, how do the courts decide? Well, the big thing there is that those words, at its discretion. And once you give the court that kind of discretion, you may as well not have the will, I think,
But then it would come down to, obviously, you would have someone representing you. Each side would have someone representing them in court. So it wouldn't just be this is the way it's going to be type thing. There would be arguments, to and fro.
There'd be arguments to and fro, but at the end of the day, the court is not bound to follow any of the arguments. They can just make up their own minds at their discretion. So it's not a question of whether the claimant gets the $50,000 he wants or not. The court can substitute any other number for that, more or less. Once you go down that road, yeah.
Are there any other laws that affect wills? Like, I'm sure there's a few of them, as you've said, but are there any ones that are particularly common?
One of the favourites that I've come across is the testamentary capacity, which is a law reform from 1949, where this is where people try to overturn Granny's will by saying she was mad or drunk.
They didn't have the mental capacity.
Absolutely right. They didn't have the mental capacity at the time the will was executed. So that means at the time the will was signed, then Granny didn't have the mental capacity to know what she was doing. that's very, very, very common and quite unfortunate most of the time.
But on the flip side, there are these horror stories where you hear somebody on their deathbed comes in and tries to get them to change their will, and they're not, they're on all these medications.
And then they do it.
Yeah.
Yeah.
But there again, there's no testamentary capacity there. So that's quite an easy one to prove, because you've got the evidence of the medical staff usually who will come in and say, no, yes, we saw them guiding her hand to sign the will document, but that wasn't legitimate. So, those ones, well, there have been some cases that have gone to court, especially unscrupulous partners trying to get their wives and girlfriends to sign over their property to them rather than children. Yes. But I don't know any that have succeeded. That is a very, very common one. The other one that's common is the testamentary promises, which I mentioned before with Carol Fry and Jason. If you're promised a proportion of somebody's estate in return for work or services, and you do that work or you perform those services, but you find in the will you've been left out, that's another valid opportunity to challenge the will.
Yeah, and I would imagine there's a few people that would do things thinking they would get something in return. There was no discussion or agreement, but then they try to use that as an argument.
That won't succeed. Yeah, well, that won't succeed because there has to be a link between the promise and the work or services. So the courts have got that one fairly worked out, actually. Over the years, they've developed a series of case law tests to see whether it's comes under the Act or not. So there must be the work or the services, there must be the promise, and there must be a causal link between the two elements. And then you look at how much has been paid. Has this person received wages instead of a mention in the will? So that's another thing to think about.
Is there any commonly asked questions you get asked about wills from non-legal friends and family, Sue?
Well, I suppose the main one is, why do I need one? And I always say, the same as I said earlier, that it's power. You don't want to lose your power just because you're not around anymore. And other people say, if I've made a will, but it's very, very old, should I review it? Well, obviously the answer is yes. You should probably review your will every 5 years. And if you marry or start a new relationship, your will won't be valid anymore, as people have found out to their cost.
So it's almost like any major kind of change, life event change, you really need to be looking at your will and updating it.
You do.
Do they ever expire?
No, only when you die.
Wow.
Because, to be honest, they don't have any effect until you die. And so you can change it as often as you like.
But if you don't change it for, say, 30 years, then, and as long as you haven't entered into another relationship, then that's still valid.
It's fine.
So how much would it cost me to go and get a will drawn up?
Oh, now, that depends. If you have a good relationship with your lawyer and you put quite a bit of work his way, like, conveyancing, setting up a family trust, that kind of thing, then they probably won't charge you anything.
Right.
It's like a bulk discount.
Oh, okay.
Yeah.
But if it's just a one-off thing and someone that I'm just walking in off the street?
It just depends. It depends how much work. It's like any piece of legal work. It depends how complex it is and what else needs to be done as part of that. It depends on what they set their rates at.
It's worth shopping around. If you don't have a regular lawyer, it's worth shopping around and finding someone to help you with it.
Okay.
And I do want to plug ture.co.nz, but that's exactly what it'll allow you to do, is shop around. So the last thing we've got time for, Sue, is have you got another tip in this episode for listeners that can be non-legal? Any tip? I know you've given them huge amounts of information, but is there any tip of the day that you'd like to offer?
Okay. Now, this isn't necessarily to do with wills. Is that okay?
No, that's totally fine.
Fine. Okay. What I'd like to say is don't panic if you get a letter through the post from a solicitor which is full of long words, legalese, that makes you look as if you're totally in the wrong and you've done something dreadful and your neighbour's going to sue you for hundreds of thousands of dollars. Don't take too much notice. Don't assume that what that solicitor has written is actually true. Now, this comes from my own personal knowledge of my son. When he was building a house up in Auckland, he bought a piece of land from an unscrupulous landowner who owned the property above. They were on a hill because it's in Auckland. And the landowner above, has his house above the piece of land that my son bought. He thought he had arranged the contract so my son would never, ever be able to build a house on the property. But unfortunately, he didn't reckon on his son having a mother who's a competent land lawyer. And my son got this full of jargon letter from the chap's solicitor telling him how he owed thousands of dollars for disturbing the drains and for doing all these things. And I looked at it, laughed, wrote a letter back, and my son never heard another word out of the bloke.
What a wonderful story about a mother and a son.
Exactly.
Good tip of the day. Don't get freaked out. Get a lawyer to look at it. Or
That's right.
If you're lucky enough to have Sue as your mum.
Very handy indeed.
Thanks so much for coming and talking to us again today, Sue. That was incredible information. And thanks, Morgan, for being here as well.
No worries. I learnt heaps.
So that's it for our latest podcast. And don't forget to subscribe and to make sure you get the latest episodes of NZ Free Law as they come out. Until then, I'm Julia Stenson, and from all of us here, take care and have an awesome day. Kia pai tō rā.